Can we deny a Philippine citizen the opportunity to go before a Philippine court? According to General Torre, and he can rebut this later on, is that 8 or 12 hours is enough. Diba? But I think mas malaking issue yon kung ang court nag-issue ng TRO within 8 or 12 hours unless, the circumstance. I think at the time na the lawyers applied, hindi nga nila alam na isasakay sa aeroplano eh.
The procedure in the ICC calls for bringing the person to a Philippine court first before surrendering the person to the ICC. So if you do not follow that, it can be argued that there is what they call abuse of process. And an abuse of process can be raised in the ICC itself. I think this is what will be considered in the September hearing scheduled by the pretrial chamber. Under the rules, objections to the legality or objections on abuse of process may be raised and resolved by the pretrial chamber, probably at the scheduled September hearing. So this remains still open, even in the ICC. The question of the validity of the surrender in view of the non-observance of Article 59 of the Statute of Rome itself. And the other thing is whether or not such abuse of process is curable. And again, that is debatable. It seems to me that the initial hearing on March 14th done by the pretrial chamber was an attempt to cure the deficiency of the absence of Article 59 procedure, because the three judges of the pretrial chamber in that hearing simply did what a local court would have done. That is, determined that the person is the same person named in the warrant of arrest and that the person was informed of the charges against him or her. And after that, they said session adjourned. So they merely supplied the defect that the absence of the custodial state's local court created. So it remains whether or not male captus bene detentus will be applied by the ICC.
What possible violations are there to local law and our Constitution?
The possible violation, Madam Chair, consists in the surrender without passing through the court, what we call extrajudicial rendition. That issue will have to be resolved by the Supreme Court, whether or not an extrajudicial rendition is valid in the Philippines in view of our Constitution. And the other issue is whether or not there is a comma that separates international tribunal from another country. In other words, whether or not the Colatilia, subject or pursuant to the applicable extradition laws and treaties, refers only to extradition and does not refer to rendition because of comma. I look at the text of Republic Act 9851, Madam Chair. Section 17 does not have a single comma. It has two commas. And the two commas are parenthetical commas. They are not separating commas. They are parenthetical because they merely enclose the words "if any." So it says that the Philippine authorities may surrender the suspect to the International Tribunal, comma, if any, comma, or to another country pursuant to the applicable laws, extradition laws and treaties. So the commas really refer only to if any. It is not meant to separate the provision that requires a treaty from surrender to an international court, in my view. So it's not a single comma. Dalawa pong comma yan. Ang function ng dalawang comma in grammar is like a parenthesis. If any, because the words if any. So To me, the violation is not doing the rendition pursuant to the applicable treaty. The applicable treaty is the Rome Statute. It is brought back into application by our own Section 17 if you do a rendition. So if you do a rendition, you have to follow the procedure for rendition in the Article 59 of the Statute of Rome.
Yes, thank you very much, Justice. And certainly, looking at the transcripts as well as the original bills filed, maliwanag po na talagang walang koma. So, ibig sabihin, pareho yung extradition tsaka surrender na kinakailangan may treaty o batas na pinagbasehan. Maliwanag po yun, kaya't aabangan natin yung hatol ng ating Korte Suprema.